With that, we begin the final round of Vidhigyaan 2025. I request everyone to kindly be seated, please. I wish all the participants the very best of luck. Now the court will be in session. Kindly maintain the decorum. Thank you.
Yes, yes, yes.
Council seeks permission to address the dais. Council seeks permission to address the bench as lordship. Council 1 is dealing with issue number 1 and Council 2 will be dealing with the rest of the issues. If your lordship is well versed with the facts, can I proceed with issue 1?
Just in brief, tell me the facts in 5 minutes.
The issue is between the petitioner, Mrs. Ruchi Sharma, and the respondent, iTube INC, who is an online video sharing platform, and the petitioner's minor daughter has been using the online video sharing platform for educational purposes, on which the respondent has been showing advertisements. The advertisements which were shown to the minor were some fraudulent advertisements provided by a website, due to which the petitioner's minor daughter clicked on the website and was induced in making some payments, due to which the petitioner's minor daughter had faced financial as well as psychological problems. Therefore, the petitioner's mother, Mrs. Ruchi Sharma, has filed the present writ petition in the Honorable Supreme Court. Can I proceed with issue 1? Issue 1 is whether iTube INC as an intermediary is immune under liability under section 79 of the Information Technology Act 2000, and does this immunity extend to harm caused by clickbait advertisements aimed at minors? Section 79 does provide a safety harbor for Section 79 does provide a safety harbor for intermediaries, but this safety harbor is not a blanket immunity. It is a conditional immunity, which in the Section 79 itself requires the intermediary to follow some due diligence before
What is section 79? First text.
Section 79 is the exemptions in which are the exemptions of the intermediaries which they have to follow, the due diligences. Section 79 2C requires intermediaries to exercise due diligence in prevention to prevent such unlawful content. In the present matter, the respondent should have consent columns in which they should have asked the users about their age, about the user details, which the respondent in the present matter has clearly failed. The respondent had shown some advertisements on their own websites, which they could have monitored if it is a lawful advertisement or what, or how is it going to hamper the user. The respondent in the present matter had actual knowledge of some advertisement which is going to harm a minor child. under section 79(2)(c), an intermediary is required to observe due diligence in discharging its duties and comply with the prescribed guidelines to prevent the hosting or sharing of harmful content. The respondent in the present matter has not only provided the advertisement but has also endorsed it in such a way that the minor daughter, was induced in making the payment and doing some financial transactions. Further, the petitioner's daughter, despite her blocking the advertisement, still the respondent failed to comply with the due diligence and remove the advertisements, but the respondent continuously showed the advertisements to the petitioners, thereby causing psychological harm to the minor daughter. The respondent's failure to act in good faith and provide meaningful responses demonstrates a lack irresponsibility and negligence on the part of the intermediary. The misleading advertisement which was there on the platform of the respondent, the respondent played an active role in showing the user of content which was not available, which should not have been shown to the minor. This exposure to such an advertisement has caused distress to the minor daughter of the petitioner. In the case of Google, on page 12 of the memorial, the case of Google India Private Limited versus Vishaka Industries Limited and another, the petitioner did not take any action to block or disable access to the defamatory material disseminated by the petitioner through its platform despite being duly notified. Similarly, in the present matter, the respondent was continuously being notified about advertisement which was shown to the minor. Despite this, the respondent merely showed automated responses to the petitioner which helped in no way to the petitioner's daughter. Under section 79(3) of the Information Technology Act, the intermediary has aided to the unlawful act of advertising a fraudulent advertisement on its website, thereby promoting such a ad which is actually not only unlawful and fraudulent for the minor but as well as also to the other users.
How it is unlawful? Is unlawful activity defined under the IT Act?
Apologies, Your Lordship. In Shreya Singhal versus Union of India, page 12 of the memorial, the Supreme Court had held that section 79 does not provide a blanket protection to the intermediaries. Immunity is lost if the intermediary has knowledge or control over the harmful content and does not take action. In the present matter, after reporting to the respondent about the advertisement, the respondent could have easily removed the advertisement and had taken some action towards the advertisement that was showcased by the party. But the respondent merely provided automated response showing a lack of interest in the complaints that were coming through a user. The respondent is a global company, and owing to that fact, the respondent should have taken some immediate action to the users.
How would the respondents know that the person using is a minor or major, or whether that person is in a capacity to enter into a contract?
On the respondent's platform, there should have been a provision in which they could have sent a message of who is it using, like is it a minor, is it a major. There are age controls, there are parental controls which the respondents online video sharing platform should have.
Does Does the law provides them to have such specific consent where on their side they have to say that what is the age of the person using it or
The complaints were made to the respondents, and for the same, the credentials will be with the respondents about the age criteria and the rest of the details. To conclude with it, the respondent failed to meet its legal duty under Section 79, subsection 2 and 3. Knowingly, it allowed harmful content to remain on its platform despite complaints from the petitioner. If your lordship is content with the arguments, I would like to call the council to.
Council seeks permission to approach the podium. Much obliged.
This is Counsel 2 appearing on behalf of the petitioner. Counsel seeks permission to address the bench as your lordship. Much obliged. Counsel 2 shall be dealing with issue number 2, 3 and 4 and shall be addressing the bench for a total time of 15 minutes. Your lordship, if you are content with the arguments for issue number 1, the counsel seeks to firstly address the questions asked by your lordship and then further deal with the arguments for issue 2. Your lordship asked whether there were any unlawful activities conducted by the respondent. The same shall be dealt with in detail under issue 2, your lordship. However, by what my co-counsel meant by the word unlawful activities is the misleading advertisements, which are indeed punishable if the same violate the rights of the users and the consumers. Moreover, your lordship also asked whether there has to be any age details available with the respondent. Your lordship, it is humbly submitted that when a viewer or a consumer makes an account on such a platform, credentials have to be put as to the name or age or gender of the viewer. As well as when a post is made on such a platform, the post has to give target or trigger warnings as to whether the same is for adult content, whether the same is suitable for children under age of 13, whether the same content is made for kids. These credentials from the posts or third-party content creators as well as the viewers are important and should be with the respondent's platform to ensure that harmful content is not reaching the children of minor age and are not exploiting their vulnerability. If your lordship may permit, counsel seeks permission to further with issue 2. Your lordship, issue 2 deals with whether iTube Incorporation can be held liable for failing to regulate advertisements that target minor with clickbait and misleading content under Indian laws. Your lordship, the Indian laws in the present matter may be understood to be the Consumer Protection Act and the guidelines made thereunder. If your lordship may kindly refer to page 20, para number 10(2), the guidelines for prevention of misleading advertisements and endorsements for misleading advertisements. These guidelines were issued under Section 18 of the Consumer Protection Act. Now, Consumer Protection Act provides that if a user whose rights have been violated is a minor, the same user may, by way of their guardian or parent or any major person, come before the Consumer Protection Authority and the damages for the same may be availed or the cognizance may be taken for such violation. Further, according to this, the guidelines also provide for misleading advertisements, the criteria for misleading advertisements, which provides that there should be truthful and honest representations. Your lordship, in the present case, the advertisements that were shown to the petitioner's minor daughter had flashy features as redeemable real rewards. They showed untruthful facts like popular with the teens. It also showed, if your lordship may kindly refer to first page of the proposition, last para, Fourth last line, where the ad promised easy money, real rewards, popular with million teens, opportunity for instant wealth. Your Lordship, these are the criteria, these are the features that are targeted towards the vulnerability of the teenager users or the child users, minor users, so that they may be exploited due to their naivety. These are exactly the dishonest representations that the misleading advertisements, that the criteria for a proper advertisement provides that the advertisement should not hold dishonest representations, should not hold misleading representations, is exactly what the guidelines provide for. Further, it also provides that it should not mislead consumers by exaggerating the accuracy and scientific validity, which is also the case in the present matter. If your Lordship may see, it is also stated that the ads should not mislead about the nature of the extent of the risk to consumers' private personal security. In the present matter, the advertisements that were targeted to the minor with did indeed show flashy and high energy features that were made to be targeted to minors such as this. And this is evident by the fact given in the proposition, where it is stated that intermediaries target minors according to their apologies, Your Lordship. Page number 1, para 3, line 3, where it is stated that these ads are targeted based on users' interest, viewing history, and demographic information. Now it is understood that users' interest and viewing history shall be taken into consideration. But Your Lordship, the word demographic information basically means the gender information, the age gap, as well as the location and the VPN history of these users. Now, it is a respondent who takes into consideration the age gap of these viewers and then targets them with the ads that will definitely exploit them due to their age as well as their vulnerability and naivety. It is thus submitted that the respondent in the present case should be held liable for clickbaiting, misleading the minor viewers on their platform, because it is the misleading advertisements that the respondent generates a huge amount of revenue from. The respondent profits and monetizes these advertisements, moreover promotes and endorses these advertisements so to exploit the vulnerable and the naive users on its platform. Your Lordship, it is humbly submitted that the constitutional framework, the Indian laws, protect minors against exploitation. It is also stated through various judgments of this honorable court that the children should be protected against their exploitation, and exploitation only due to their vulnerable nature and naive nature. If Your Lordship is content with the arguments of issue 2, Council seeks permission to proceed with issue 3. Your Lordship, issue 3 deals with whether the petitioner, especially as a minor, has the right to be protected from deceptive and harmful advertisements under the constitutional framework and relevant child protection laws in the nation of Indica. Your Lordship, the Constitution of Indica under Article 39F provides that the children shall be protected against any exploitation thereof. It was also held in the case of apologies, Your Lordship. Kindly refer to page 18, para 9.6, where this court, in the case of Ajay Goswami, held that Ajay Goswami versus Union of India, held that the right of minor flows from Article 19(1)(a), Article 21, read with Article 39F of the Constitution of India, and under United Nations of Convention of Rights of the Child. It is held by this court that Article 39F should be considered as a safeguard to the children so as to protect them from any exploitation. It was also stated in the case of, if Your Lordship may kindly refer if Your Lordship may kindly refer to page 24, para 5, in the case of Lakshmikant Pandey versus Union of India, where it was held that, apologies, Your Lordship, kindly refer to page 25, first paragraph, third last line, where it is held that clause F of Article 39 provide that the state shall direct its policies towards securing inter alia the tender age of the children is not abused, and that childhood and youth are protected against the exploitation. It is humbly submitted that this court,
This
through
exploitation is what, physical exploitation or the monetary exploitation or psychological exploitation?
Your Lordship, the word exploitation is a blanket term which is considered physical exploitation, which is provided under the criminal laws, which is the BNS and the POCSO. Psychological or financial exploitation, which is also safeguarded by Article 39, as well as under Consumer Protection Act, as well as under the IT Act through these guidelines against misleading advertisements, as also a national policy for children in 2013 was adopted by the government, wherein there is a preambulatory statement which states that best interest of children is a primary concern in all decisions and actions affecting the child, whether taken by legislative bodies and so. If your Lordship may kindly refer to page 23, the preambulatory statement states that safety, security and of all children is integral to their well-being, and children are to be protected from all forms of harm, abuse, neglect, violence, maltreatment, exploitation of all settings, including care, institution, schools, hospitals, families and communities. Your Lordship, the respondent in the present matter may be considered a kind of a community, as it is a widespread video streaming platform wherein users connect with each other according to their interest, as well as content creators connect with each other according to their interested content. Furthermore, Your Lordship, it is also submitted that even though there are laws that in force that protect children or consumers against any misleading advertisements or any harmful, abusive content created online, there are no specific regulations or specific provisions in place that protect specifically the children against exploitation which targets their naivety and vulnerability due to their age, which is what issue 4 deals with. If your Lordship is content with the arguments of issue 3, Council seeks permission to deal with issue 4. Issue 4 questions whether the existing legal framework of the Indian nation is adequate to address the safety, and if not, what is the need for new laws to ensure security and ensure prevention of exploitation of children. Your Lordship, it is humbly submitted that the nation of India is signatory and has ratified to many of international conventions and treaties. To name the few are the United Nations Convention of Rights of the Child, the Convention of Elimination of All Forms of Discrimination Against Women, which also can be considered in the present case given that the minor is also a girl child. We Protect Global Alliance, all of these conventions to which the nation is a signatory, and moreover the sale of children, child prostitution, child pornography, which also addresses pornography, children exposed to pornography on online platforms against their will, to which the nation has ratified. Your Lordship, it is humbly submitted that although there are laws present that protect consumers from any exploitation or harm, there is a grave need that children should be protected through stringent and strict codified laws that will protect the children from getting exploited solely due to their naivety.
Can the court make the law?
Indeed not, Your Lordship, but the court may at least recognize the need for the law, which also should be a great step in making of these laws.
Thank you.
If you
Anything else you want to say?
the council only seeks to bring to the attention of this court one case law, again of Lakshmikant Pandey, wherein this court had observed that children are supremely important, and now obviously children need special protection because of their tender age, physique, mental immaturity, and incapacity to look after themselves. That is why there is growing realization in every part of group that child must be brought up in atmosphere full of love and affection and without any exploitation. This has been observed by this honorable court through many of the judgments, and it is humbly submitted that the court observes the same now as well. If your lordship is content with the arguments, the council seeks permission to proceed with prayers. Whereof, in the light of facts stated, issues raised, arguments advanced, and authorities cited, petitioner humbly pray before this honorable court that it may be pleased to adjudge that the iTube incorporation as an intermediary is indeed not immune to the liability under Section 79 of IT Act. iTube incorporation should be held liable for failing to regulate advertisements and showing misleading advertisements, clickbait advertisements to target minors under the Indian laws. The petitioner, as a minor especially, has the right to be protected under the constitutional framework as well as relevant child protection laws, and the existing framework, even though in force, are not enough for protection of children against their exploitation due to their vulnerability, and the international law should be taken into consideration to form new laws, and that this court may observe the same. Much obliged, Your Lordship.
The council seeks permission to approach the dais. The council seeks permission to address the bench as your lordships. Much obliged. Lordships, I would strongly like to contain what the co-counsel of the petitioner said. I will structure my arguments in points. To start with the first issue, I would like to state that iTube incorporation is merely an intermediary and does not curate content directly. As if in Lordships, Section 79 of IT Act 2000 grants safe harbor protection to the intermediaries that merely host the third-party content and do not curate, modify, or promote them. Your Lordships, as it was held in Shreya Singhal versus Union of India, the case of 2015, this honorable court held that an intermediary cannot be held liable unless it has the actual knowledge and fails to act upon it. Further, your Lordships, as of the second point is concerned under the issue 1, I would like to state that the due diligence obligations under the IT Rule 2021 were surely complied by iTube Incorporation, as if in your Lordships, iTube Incorporation has fulfilled this due diligence obligations. Your Lordships, AI-based filtering and grievance readdressal mechanism were provided by iTube Incorporation. Further, your Lordships, I would like to contend that in the case of Google India Private Limited versus Vishaka Industries, the case which was held in 2020, this honorable court reaffirmed that an intermediary is not liable unless it actively modifies, curates, or promotes the content, which iTube Incorporation is surely not doing here. It cannot be expected to manually screen every advertisement uploaded by advertisers, as this would be an impractical burden contrary to the principle of intermediary neutrality. Further, your Lordships, the use of AI-based targeting does not remove the safe harbor protection under Section 79 of IT Rules 2000. As if in your Lordships, it was held in Amazon versus MAV, the case of 2020, that automated content ranking does not amount to active promotion. Thus, iTube Incorporation qualifies for the safe harbor protection. Fourthly, posing liability on iTube Incorporation will definitely lead to a dangerous precedent. As if in your Lordships, holding iTube liable for every third-party advertisement would be unreasonable and contrary to international and legal principles. A contrary ruling would open the floodgates for litigation against intermediaries for every piece of third-party content uploaded by the users. Additionally, your Lordships, I would like to state that this writ petition is not maintainable. Under IT Rules 3, subclause 2, This mandates that intermediary must establish a grievance redressal system, which ITUB has done. And also an automated response was sent it to the petitioners to calm them down and to reassure them that we are working with their complaint. Further, your lordships, it is also not maintainable because the alternative remedies were not exhausted. If the grievance officer of the incorporation is not complying with what the petitioners are saying, or if they are not satisfied with the solutions provided, they could have approached the IT ministry. A specialized cell has been allotted under it, which is IT cell. It is under the Rule 4, subclause 6 of Significant Social Media Intermediaries Act under IT Rule of 2021. So, reaching out to IT cell would have been a better option rather than directly coming to the Supreme Court. Further, alternative remedies also exist, such as High Court. So, the hierarchy should have been followed because IT rules already lay them down. Your Lordships, to start with the second issue, I would like to contend that liability under Consumer Protection Act 2019 is on the advertisers and not on the platform which merely provide a ad space. As if in section 2, subclause 28 of the CPA defines misleading advertisement, but it does not extend liability to intermediaries that merely host them. Section 21 empowers authority to take action against advertisers, not against the platform itself. It was held in Dabur India versus Colgate Palmolive India Limited, and also in Francis Vadakan versus A1 Medical and others, that advertisers and not the hosting platforms bear the responsibility for the deceptive ads. Further, your lordships, the ASCI code is not legally binding statute on the intermediaries. The ASI code governs advertisers and set ethical standards, but it does not impose legal obligations on the platforms like ITUB Incorporation. As if it was seen in Horlicks Limited versus Zydus Wellness Products Limited, it was held that advertisements ethics apply to creators of the advertisement and not a platform which is hosting and giving the mere ad space. Your Lordships, ITUB Incorporation has implemented a robust complaint redressal mechanism. Upon receiving complaints, ITUB Incorporation removes the misleading ads in accordance with IT Rules 2021. Unlike Marico Limited versus Adani Wilmar, in which the hosting platform was itself indulged into creating the advertisement and promoting them selectively. Your Lordships, there is also a prominence of a very relevant maxim here, which states, "He who acts through another acts himself." Here, the advertisers are acting through intermediaries, and hence it is the advertisers who are liable and not the intermediaries. Further, your Lordships, I would like to state that the violation of data protection laws have definitely not been occurred over here, as if in as if in data protection laws requires platform to obtain consent before processing children's data. The petitioner has not provided any proof that ITUB Incorporation unlawfully processed Swara's personal data. I would also like to state that the daughter of the petitioner, the Swara, she was using the ITUB Incorporation from major account, as if in the mother of Swara allowed the access of her account, her phone, and her credit card credentials, which are very sensitive to be shared with anyone, even to our closest relative. She shared it with minor, and now she is posing the whole mere responsibility on the intermediary. And also, your Lordships, the amount of 500 which went in fraud was from the third party advertisers and not from us. So it is the third party advertisers who should have been made a party in this rather than making us liable for it. Further, your Lordships, it is clearly stated that the petitioner's daughter was directed from our website to a third party website. That means she would have gotten a disclaimer or something that she has been directed. She would have knew it. So she would have been more vigilant towards it, that she is being directed, and she on voluntary basis she provided her data and everything over there. So how come an intermediary is responsible if the petitioner's daughter is providing the data voluntarily to a third party website which she has been redirected to? I would also like to contend that posing psychological harm is not something very relevant here. As if in anybody could claim psychological harm, but there are no reports and no evidence to prove the psychological harm, your lordships. So I would like to conclude it in this way, that the third party advertisers are liable for this and not us, because we do not actively curate the advertisement. Also, the remuneration should be taken from the third party advertisers and not us, because it was not us who got the money fraudly, it was a third party advertisers here. And further, your lordships,
But is it not your duty to verify what is posted on your platform? That is number one. And number two, is the writ an absolute, is an alternative remedy absolute bar for approaching the writ court?
Can you repeat the second point again?
Your argument is that there was an alternative remedy which they have not exhausted, therefore they cannot approach the writ court directly. Is it an absolute bar that wherever there is an alternative remedy provided, a person cannot approach the writ court at all? Or is it a discretionary? Discretion to be exercised by the court.
Your lordships, to start with the first question raised by you, I would like to state that it is basically the responsibilities, as if it was laid in Shreya Singhal case. It states that if the intermediaries are only liable when they have actual knowledge and when they fail to act upon it. If one person approaches us and he want to post the advertisement on the platform, we may not be knowing his intent behind doing that. What we would see is the same thing that petitioner would see. But when we receive the complaint that there is something fishy going at the back, we came to know the intent of the advertiser. At that time, we are liable to take action on it, and hence we send it them an automated message, and we give them a composure that we'll act on it.
Come to the second question.
Second question, I believe it is discretionary, but what is laid down is you should be following the process. As if if everyone approaches the Supreme Court, there would be a flooding of litigations in the Supreme Court. That's why we have legislature and laws to take down. Yes, sir. I would like to pass it to my co-counsel for further proceedings.
Council seeks permission to come to the. Council seeks permission to address you as Lordship. Moving forward with the issue third, which is whether the petitioner as a minor has the right to be protected from deceptive and harmful advertisements under the constitutional framework and relevant child protection laws of India. So, your Lordship, digital safety is a shared responsibility. In Justice M.K.E.S. versus the Union of India, this honorable court had held that users, including the parents, must take proactive steps to ensure digital safety. ITO incorporation provides parental controls, restricted modes, and content moderation tools, which the petitioner has failed to utilize. Your Lordship, while we acknowledge the importance of protecting child online, ITO incorporation is not legally obliged to ensure an ad-free experience for every minor user. But in the case of Francis Coralie Mullin versus the Union of India, the right to dignity was upheld, but it was never extended to hold intermediaries accountable for the third-party content. Further, your lordships, there is no violation of the Juvenile Justice Act. The section 75 of this act applies only to direct exploitation of the minors, which does not include exposure to advertisements. In Fahima Shireen RK versus the state of Kerala, this honorable court ruled that parents and the guardians bear the primary responsibility for monitoring the minors' digital activities. Moreover, it is said that one cannot benefit from their own negligence. It applies here since Mrs. Sharma failed to enable the parental controls. The blame cannot be shifted to ITU Incorporation, sir. ITU Incorporation has taken reasonable steps to ensure children's safety, and the responsibility ultimately lies with the legal guardian and the parents. I would like to move forward with the issue fourth, which is whether the existing legal frameworks are adequate to address the safety and protection of children on online platforms, and if not, what is the need for new laws and guidelines to ensure their security and prevent exploitations. Your Lordships, Indica's laws are already in alignment with the international standards. The DPDP Act 2023 prohibits targeted advertisements for minors, bringing Indian regulations in line with the European Union's GDPR and USA's COPPA. In XYZ versus Google India, this honorable court held that intermediaries must comply with data protection laws, which ITube Incorporation does. Further, the IT rules of 2021 already mandate content moderation. Here, Rule 3, Subclause 1B prohibits harmful content, and Rule 4, Subclause 1, it requires grievance redressal, both of which the IT Incorporation has followed. In Facebook versus Surinder Malik, the court held that intermediaries must act swiftly on complaints. Here, the IT Incorporation has also complied to it. Your Lordships, enforcement and not additional regulations is the key here. In Kamlesh Vaswani versus Union of India, this honorable court ruled that stricter enforcement of existing laws is preferable to unnecessary new legislations. If it applies that instead of imposing additional restrictions on intermediaries, we should focus on better enforcement of the current laws. If the court has any questions, or else I would conclude our arguments. Should I conclude? Your Lordships, in the light of the submissions made, we respectfully submit that ITube Incorporation is an intermediary protected under the Section 79 of the IT Act, as it does not create or endorse any advertisements. Liability for misleading advertisements lies with the advertisers and not the hosting platforms. ITube Incorporation has implemented child safety measures and parental responsibility, which cannot be ignored. The current legal framework is robust and in line with the international standards. Making additional laws unnecessarily will complicate things, and instead implementation should be emphasized.
What suggestions you have to improve the existing rules and regulations on this issue?
Sir, like I said, we have the Data Protection Act, which has newly been introduced. We should follow there some rules of it as well, and the rules like we mentioned, which prohibits harmful content and provides a grievance redressal. So, like ITube Incorporation has followed them, we want to say that we are not the ones who should be who should be standing.
My question is not whether you are following or not following.
Yes.
My question is what suggestions you can make for enhancing the improvisation of the existing rules or regulations.
So we can prepare specific guidelines which is focusing on the minors, but as I said, we feel the international standards, we are in line with the international standards, and no improvement is needed. The law enforcement is what we should focus more on, and not new legislations. Hi, State. Can we continue with the prayer?
The prayer is to dismiss the...
Yes, to end.
Dismiss.
It is
to hold that ITube Incorporation is a mere intermediary and is subject to the safe harbor protection under Section 79 of IT Acts 2000. To hold that ITube Incorporation has complied with the due diligence obligations under IT rules, and to dismiss the petition of petitioners hereby. We hope we have pleased the bench to give the judgment in favor of justice.
Thank you.
Permission to sir rebuttal, Your Lordship. Much obliged, Your Lordship. Your Lordship, it is humbly submitted by the petitioner that none of the statements made by the respondents are backed by any of the solid proofs. The respondents may state that they have put in force the parental guidelines and grievance redressal systems, but there is no mention of any parental guidelines in the proposition, and the same cannot be alleged by the respondents out of the thin air. Moreover, the grievance redressal systems that the respondents speak of, it is only an automated message, is what people expressing their grievances get. No other action, no further scrutiny of the complaint, no further real action taken against the complaints made are seen neither in the proposition, and it is clearly evident from the proposition that at no point in time has the respondent ever taken cognizance of these complaints, because it can be clearly seen, Your Lordship, that these ads boast popular with millions of teens as their one of their selling points. Now, if these ads are so popular with millions of teens, there surely must be a boast about these advertisements, or some way the respondents must be aware that these kind of advertisements are being shown on their platform. If the respondents are monetizing from the same, it is a given that the respondents are supposed to be aware of the same, and if the respondents are aware of the same, the respondents are obliged to take care of the same. Even if same cannot be considered in the fair interest of justice, the section 79, which provides exemption, also provides under section 79 subclause 3 that the exemptions may not be applicable if under section 79 3b, if the intermediaries have actual knowledge, which in the present case the respondents have the clear knowledge, as the petitioner has clearly made a complaint regarding the same, but there is no action taken by the respondents. Moreover, Your Lordship,
But how can you say they had a prior knowledge? They had knowledge after it was pointed out to them.
indeed.
So can you say that they had a prior knowledge when the advertisement was uploaded on their platform, that they knew this will be the harmful effect?
Indeed, Your Lordship, it is given in the proposition, first page, para 3, that these ads are targeted based on the user's interest, viewing history, and demographic information. These ads are not given out by the advertisers, but they are targeted by the platform. The platform recognizes the kind of
Got your point.
Indeed. Your Lordship, it is humbly submitted that the respondent also mentioned AI filtering. However, that is not the case. It is again according to the demographic information that the platform targets the advertisements. Moreover, the respondent states that due diligence is not an obligation, contrary to which section 79 subclause 2 mentions that due diligence has to be exercised by the intermediaries. It is a clear obligation upon the intermediaries, and if the respondents are clearly mentioning that we do not curate our content, that we do not exercise due diligence, they are clearly liable in the present case, and the same should be imposed upon them. Moreover, Your Lordship, it is humbly submitted, if Your Lordship may kindly refer to page 21 of the memorial for the petitioners. Paragraph F, wherein in the case of Indian Medical Association versus Union of India, it was stated that we are of firm view that advertisers and advertising agencies and endorsers are equally responsible for issuing false misleading advertisements. Such endorsements that are routinely made by influencing platforms get a long way in promoting a product. Now, the product may be from some different website. However, the respondent in the present matter is the endorser, is the influencing platform. If a platform is so globally famous, if the platform is used by millions of viewers and content creators, it is indeed an influencing platform, and anything shown on these platforms are bound to take attention of their viewers. Furthermore, Your Lordship, it is humbly submitted that the parental controls are not mentioned in the proposition, and the same cannot be relied upon the respondents, but also to recognize the responsibility of the petitioners, that the petitioners as the guardian and the parent of the minor in the present case should have been aware. It is submitted that the parents were indeed aware that the minor was accessing this account for only educational and recreational purposes. Now it may happen that children sometimes may take some actions that the parents are not right away aware of, but it is important that the parents are aware of about their children's actions at the earliest, which is indeed the present case. There may have happened an incident that the minor have taken some wrong steps, that the minor may have been influenced by some harmful activities on online platforms, but the parent, the petitioner in the present case, was indeed aware of the same at earliest and has taken cognizance and action of the same. Much obliged, Your Lordship. That is all the submissions. If Your Lordship is content, the petitioner may take seat. Much obliged.
The council seeks permission.
Why? Was sir rejoinder? No sir rejoinder. Only rejoinder. Why you want? She did not say anything new. She only replied to what you had said. So unless she says something new, you cannot have a right to rejoin. Okay?
Okay, sir.
Student ushers may kindly guide the mooters back to their places.